when you go up and you get into a pissing match with officers, who's going to win? Who's going to win? Every single time. If you go up and you mess with someone who has the power of arrest, you're going to lose every single time. Don't go. It's not hard. Ma'am, you are charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On September 26, 2024, at approximately 1:15 p.m., an officer responded to a call at the TSU Library Center located at 3100 Claiborne Street in Harris County, Texas, regarding a disturbance. The officer made contact with the individual causing the disturbance, and the defendant approached asking officers what's going on and what did she do. The officers repeatedly asked the defendant to step back, and she became belligerent, asserting that they were at her store. She eventually complied and moved away, but she insisted that a police supervisor be called to the scene. TSU Sergeant Barnett arrived and spoke privately with the defendant. Afterwards, responding officer requested the defendant's information to report her behavior to her supervisor in the university. The defendant refused to provide it and attempted to bypass the officer. When the officer asked her to identify herself again, the defendant declined and attempted to walk away. As the officer tried to detain her, she began to throw herself on the ground and yell, escalating the disturbance. Several officers issued verbal commands for her to comply. The defendant continued to resist, jumping around and asserting her rights. The officer attempted to escort her outside. The defendant then wrapped her arms and legs around a pole, continuing to yell. The officers physically pried her from the pole and detained her. The defendant used her body weight to resist and push against the officers. The defendant was then placed in the back of the patrol car without incident.
What was she doing wrong?
So it appears she wasn't the initial person causing the disturbance, but when they came to respond to the disturbance that they were called for, she intervened. And once they asked her to remove herself from the situation,
And you didn't say, when you initially started saying about everything, you didn't say that she was the initial cause of the disturbance, that there was a call for a disturbance. They get out there and she, I guess.
So what it says is that they made contact with the individual that was causing the disturbance, and then the defendant approached asking.
See, right. So she just comes up, starts being nosy, right?
Right.
And then she basically, I guess, is trying to leave. And then they start asking her for her information.
Well, they were asking her to leave the scene so that they can respond to the disturbance, and she wouldn't comply. I think that's the issue, that she wouldn't leave when they asked her.
Did you say that?
Yes.
The defendant is charged with interference to the duties of a public servant, 6 months in jail and or a $2,000 fine. The facts are straightforward but somewhat ridiculous. Officers responded to a disturbance call at TSU Library Center on September 26th at 4:15 p.m. They made contact with the individual causing the disturbance, but then the defendant approached the officers asking what's going on and what the person did. She was being nosy, that's it. Officers asked her to step back. She became belligerent. She started asserting that they were at her store, which makes no sense. Officers were at a library, not her store, but she was claiming some kind of ownership or authority over the scene. Eventually, she complied and moved away. That should have been the end of it. But then she insisted that a police supervisor be called to the scene. A sergeant responded and spoke with her privately. After that conversation, the officer requested her information to report her behavior to her supervisor at the university. That's when things escalated. She refused to provide identification. She attempted to bypass the officers. When they asked again, she refused again and tried to walk away. Officers attempted to detain her. She wrapped her arms and legs around a pole and started yelling. Officers had to physically pry her from the pole. She used her body weight to resist. Eventually, she was placed in the patrol car. So the question becomes, What specifically did she do that constitutes interference with the duties of a public servant? She asked questions. She claimed the officers were in her store. She refused to identify herself. She resisted detention, but was any of that actually illegal? The judge is immediately skeptical. What was she doing wrong? He asks. Because reading the facts, it sounds like she was being annoying, not criminal. She was being nosy. She was being belligerent. But there's a difference between being an annoying citizen and actually interfering with an officer's duties. The prosecutor tries to explain. She wouldn't leave when they asked her to. She wouldn't comply. That's the interference. But the judge isn't convinced. Because being asked to leave and not leaving immediately isn't necessarily interference, especially if the officer's explanation is weak.
They asked her to move away from the scene and she refused to comply.
Will you read that part again?
So when she approached the officers repeatedly asked the defendant to step back, and the defendant became belligerent, asserting that they were at her store. She eventually complied and moved away, but
So she complies, she moves away.
right. But then she came back.
Okay.
And so at that point, when she returned, they asked her to identify herself. She refused to provide her identification. And then at that point, when they asked her to identify herself, she attempted to bypass the officers.
She leaves. She's trying to leave.
She is attempting to, she's
leaving.
attempting to leave again.
And then they start bucking up to her.
Sure, yeah.
Judge, what is this case?
It's on for tomorrow's docket. Let me give you the cause number. 251-1137.
Sounds like interference. So
That's what she's charged with. But so sounds like she's got a case of the nosies, you know? She goes up there allegedly being nosy, leaves, comes back, and then they start asking for her information. She declines to give her information.
So, Judge, what I'm looking at here, just to add context to the situation, she approaches in an unrelated incident, it looks like.
Correct.
She's asking what's going on. Fine. They talk to her individually. Okay. They tell her to leave. She continually asks what's going on. What did she do? She asserts, she becomes belligerent, is what the officer says, asserting that they were at her store, obstructing their investigation. Eventually, I don't know what the time frame is, but they say eventually she complies, moves away, but insisted that they need to call a supervisor to the area. A sergeant then spoke with her privately. After they responded and they requested her information to report her behavior to her supervisor at the university, and to identify her, which she refused to do. She then attempts to bypass officers. They ask her for identification again. They're detaining her. She says no.
But what's the interference? What did she specifically do?
Well,
She's just talking to them.
I understand,
Right.
Judge. She's talking to them, but she's saying that they're at her store. She's belligerent, telling them to leave. They're at her store. The position of the state judge is that did obstruct their investigation. I mean, it's not in this. There's multiple senses of obstruction in our opinion. It's not.
Are you losing right now? Okay. Yeah, I'm not buying it.
Okay.
I'm not gonna do it. All right, I'll find no probable cause.
I'll dismiss the case, Judge.
The judge starts breaking down what actually happened. So when she approached the officers repeatedly asked the defendant to step back, and the defendant became belligerent, asserting that they were at her store. She eventually complied and moved away, right? Yes, she complied and moved away. But then she came back. The judge asks. Yes, she came back. And when she came back, they asked her to identify herself. She refused. The judge is mapping out the timeline. And what he's finding is that most of what's described doesn't actually constitute interference. She approached. They asked her to step back. She stepped back. That's compliance. Yes, she was belligerent and annoying, but that's not illegal. Then when she came back and they asked for ID, she refused. And that's when things escalated. But even refusing to identify yourself, while not advisable, automatically constitute interference. The defense argues that she was just talking to them, asking what's going on. She was being nosy, but is being nosy a crime? The prosecutor counters that her assertions that they were at her store and her belligerent behavior obstructed the investigation. But the judge is skeptical. "I'm not buying it," he says directly. Then the judge delivers the knockout blow. "Sounds like she's got a case of the nosies." That's his diagnosis, not interference, not obstruction, just nosiness. She wanted to know what was happening and she wouldn't leave when told to. The judge's ruling is clear. "I'll find no probable cause. I'll dismiss the case." But before she leaves, the judge gives her some blunt wisdom. When you go up and you get into a pissing match with officers, who's going to win? Who's going to win? Every single time. If you go up and you mess with someone who has the power of arrest, you're going to lose every single time. Don't go. It's not hard. It's not complicated. Officers have authority. Citizens don't. If you argue with someone who has the power to arrest you, you lose. Every time. It's not about who's right legally, it's about power dynamics, and the defendant had none.
I found no probable cause in your case, ma'am. Just be careful, okay?
Can I ask a question?
Sure.
If I want to press charges,
Don't. You know what? Let sleeping dogs lie. Don't.
they assaulted me, though. They knocked out my tooth. They chipped my tooth. I got bruises on me.
And you can always go file a complaint with Internal Affairs,
That's what I'm asking.
whatever.
Like, how could I do that? I don't know the protocols.
Just when the case is ending, the defendant asks a question: "Can I press charges?" The judge's response is pragmatic: "Let sleeping dogs lie." But the defendant isn't done. "They assaulted me. They knocked out my tooth. They chipped my tooth. I got bruises on me." Wait, what? This changes everything, or does it? The judge listens, and his advice is measured. You can always go file a complaint with Internal Affairs. The defendant says she doesn't know the protocols. The judge tells her, find out which agency it was, Texas Southern University Police, and file a complaint with their Internal Affairs Division. Take everything she has documenting the alleged assault, photos of injuries, medical records, etc., and file that complaint. But here's what's important. The judge doesn't say, yes, let's press criminal charges. He doesn't say that's assault and we should prosecute. He says file an Internal Affairs complaint. Why the difference? Because criminal assault requires specific elements. It requires intent. It requires excessive force beyond what's necessary to effect an arrest. And when an officer is attempting to arrest someone who's resisting, wrapping themselves around poles, pushing against officers with their body weight, some level of physical contact is inevitable. The defendant resisted. The officers had to physically remove her from the pole. She got bruised. She lost a tooth. But was that assault, or was that the natural consequence of resisting arrest? The judge isn't dismissing her injuries. He's acknowledging them and giving her a pathway, Internal Affairs, to have them reviewed. Internal Affairs can investigate whether the force used was excessive. They can determine if there was misconduct. But the judge also isn't going to pivot from dismissing her interference charge to prosecuting the officers for assault based on her word alone and her visible injuries. It's a practical judicial response. You lost your case because there was no probable cause. You have injuries that you believe were caused by police misconduct. Here's how you address that. File a complaint with Internal Affairs. That's the proper channel. The defendant leaves having been dismissed, but also having been given guidance on how to address what she believes was excessive force.
So, what agency was this? Is this, did you say it was at a college or?
Yes.
Okay. So you go to the Texas Southern University Police, you go to Internal Affairs, and you can file a complaint that way. Okay, I would take everything that you have, and that's how you do it. Okay, but just be careful.
What we just witnessed was a masterclass in judicial skepticism and common sense. A defendant was charged with interfering with a public servant for being nosy, asking questions, and refusing to comply with an officer's directive. The judge looked at the facts and found them insufficient. She didn't obstruct. She didn't interfere. She was annoying. Being annoying isn't a crime. So the judge dismissed the case. But then the judge delivered something more valuable than the dismissal. He delivered wisdom. When you go up and you get into a pissing match with officers, you're going to lose every single time. That's not legal advice. That's life advice. It's him recognizing that the defendant doesn't understand the power dynamics at play. When you're talking to someone with the authority to arrest you, you're not in a negotiation. You're in a power imbalance. And if you push back, resist, refuse to comply, you lose. Not because you're wrong legally, but because power matters. Then the twist: the defendant claimed she was assaulted, knocked out teeth, bruises. The judge didn't dismiss this. He validated it and gave her a pathway, internal affairs, to have it properly reviewed. What's most striking is the judge's consistency. He wasn't protecting the officers. He wasn't dismissing her claims. He was simply saying, this is the appropriate channel for that complaint, and here's how you do it. If this case made you think about your rights when dealing with police, about power dynamics in court, about when you should push back and when you should comply, share your thoughts in the comments. Subscribe for more courtroom analysis where we see real judges making real decisions about real people. And remember, sometimes the most important lesson a judge can teach is practical wisdom, not just legal doctrine.